One of the issues I wanted to talk about tonight was the constitutionality of the war in Libya. I'm Professor Robert Delahunty. I teach constitutional law and international law and a few other subjects at the University of St. Thomas School of Law in Minneapolis, Minnesota. The Obama administration addressed this issue fairly early on in the course of the U.S. intervention, and the Justice Department made an argument that essentially had three steps. First of all, it said, and I think very few people would seriously dispute this, that the president has some independent measure of constitutional authority to project force abroad. The second step OLC made was to say that if the Constitution imposes any kind of check or constraint on this discretionary power of the president's, it is found in the Declare War Clause. The third step that OLC took was to say that the intervention in Libya wasn't really a war within the meaning of the Declare War Clause because it was the nature, the scope, the projected span of the intervention didn't amount to a war, and it cited some of its own fairly recent precedents on Somalia, Haiti, Bosnia, and Kosovo in support of that view. Now, I think that argument is fundamentally mistaken because it introduces into the constitutional analysis a distinction between large and small wars. The text speaks of war without differentiation between large and small wars. If you look at contemporary English usage at the time of the founding, go back to Dr. Samuel Johnson's Dictionary of the English Language, you will see Johnson saying that war is violence at the command of a sovereign against withstanders. There's again no distinction there between large and small wars. What then do they cite in support of it? Well, they look back at 200 years of constitutional practice, and they say that it has occurred with some frequency that the president has deployed U.S. forces overseas into conflict without prior authorization from Congress. But it doesn't support the distinction between large and small wars. It doesn't support the idea that large wars are for Congress to authorize, small wars the executive can initiate at its own discretion, because there have been many occasions in which the president has unilaterally started large wars. And the classic example is the war in Korea, for which President Truman had no antecedent congressional authorization at all. So OLC's argument, I think, proves more than OLC wants. It proves, if anything, that the president can unilaterally take us into war, large or small, not that his power extends to small wars, but not other wars. In short, I think analytically, when you probe it closely, the OLC opinion really doesn't make sense. It's a piece written for an occasion, only it's not a serious contribution to the jurisprudence of the constitutional war powers.